Good morning, ladies and gentlemen.
Good morning.
Would the clerk please call the calendar?
Thank you, Your Honor. Case number CV 12-1343Z, Carl Keller versus City of Auburn. For the record, counsel, will you please stand and make your appearances?
Good morning, Your Honor. My name is Howard Phillips. I represent Mr. Carl Keller, the gentleman seated to my right.
Good morning, Mr. Phillips. Mr. Keller, good morning.
Good morning, Your Honor. Jeremy Cullenberg, Keating, Buckland, and McCormick for the city and Officer Powell.
All right, good morning, counsel. This matter comes before the court on the defendant's motion for summary judgment, docket number 16. This is the time we've set for oral argument. Let's hear from the moving party.
Good morning, Your Honor. This case involves Fourth Amendment allegations of unreasonable seizure. There's three main issues: the authority to conduct a Terry stop in this case, the scope of an allowed Terry stop, and the use of force in effecting an arrest. There are some miscellaneous related claims, but plaintiff's response briefing narrows the issues and seems to admit that the Terry issues are the central issues here. Unless the court has any specific questions at the outset, I'll give a brief overview of the facts and then start with the Terry issues.
Well, before we get there, let me just address one issue. The plaintiff moved to strike one of the videos filed by the defendants, which contains surveillance footage at the Auburn jail. I believe that motion to strike should be granted. Nothing that occurred at the jail has anything to do with whether or not this was a proper Terry stop or a lawful arrest. And so I won't be considering that video. I have reviewed the other videos that were presented and for which there was no motion to strike.
Thank you.
August of 2009, the Seattle Police Department put out a bulletin to area law enforcement agencies indicating that a suspect named Chucky Mitchell was wanted for a felony domestic violence and had also threatened to, quote, shoot up a house. Had been arrested various times before, was considered armed and dangerous. Seattle Police Department asked area law enforcement to be on the lookout. They also gave the description and a license plate number of Chucky Mitchell's vehicle that was registered to him. Fast forward, after that bulletin had been issued, Officer Betts, who's not a defendant here, was of the Auburn Police Department, was working off-duty traffic flagging job in a local construction zone in Auburn. Happened to notice that the car that was the subject of the bulletin from Seattle Police Department came past him. Recognized the car, recognized the occupant as Chucky Mitchell, and recognized the license plate of the vehicle as being the subject of the bulletin. He immediately radioed Auburn Police, indicating that he had just seen the suspect in the vehicle with the correct license plate pass his location, gave a general description of the direction of travel of the vehicle. Immediately, Auburn Police start filtering toward the scene to locate this vehicle. Another officer shortly thereafter sent out over the air that this vehicle was registered at a local apartment complex and that he was familiar with the apartment complex, familiar that this is where Chucky Mitchell lived. Chucky Mitchell had been involved with various incidents with the Auburn Police and was known to several of them. So Officer Pryor gets on the radio, says, hey, Chucky Mitchell lives at this address. Somebody might want to check that out. Officer Powell, who is the defendant here, happened to be closest to the address of the apartment complex, said, I'll check out the apartment complex. Officer Powell, within a couple minutes, arrives at the apartment complex, starts driving slowly through the complex. It's one of these large complexes with multiple buildings and parking lots. As he's pulling past the driveway, he stops and he sees the vehicle that he's looking for with its brake lights on in the middle of the parking lot, engine on, running. There's a gentleman standing next to the driver's side, appears to be looking down into the car or speaking to someone in the vehicle with some items on top of the car. At that point, Powell just stops, is waiting for a second. As soon as the gentleman standing next to the vehicle looks up and sees Officer Powell, immediately says something to the driver of the vehicle, throws something on the ground, puts everything he's holding into one hand.
Well, you say throw something on the ground. Wasn't that disputed? Did the officer remember that in his deposition?
I believe the officer did remember that.
You want to cite me to the page?
I don't have a citation for you, I'm sorry.
Well, it'd be helpful if you could do that.
Okay. Immediately upon seeing Officer Powell, the gentleman walks around the back of the car, looks at Officer Powell, and starts walking the opposite direction away from the car. And the car immediately pulls into a parking spot on the left. The gentleman who was next to the car, who it turns out is the plaintiff here, Mr. Keller, looks at Officer Powell and starts walking the opposite direction. At that point, because the vehicle and the party are splitting up, it's the vehicle that they're looking for, registered to a violent felon who's got a warrant out for his arrest, who's known to be armed and dangerous, has threatened to shoot. Officer Powell turns his lights on, pulls around the corner, immediately gets out, goes around the backside of his car, draws his firearm, and orders the plaintiff, "Show me your hands, get on the ground." Those commands had no effect at all, as is clear from the video. Mr. Keller goes on about his business, ignores Officer Powell for several commands, then begins to curse at him and refuse the commands, tell him, "What are you going to do, rookie? Why are you running up on me like that? You better call for backup. What are you going to do?" Powell continues to say, "Get on the ground, get on the ground, get on the ground," at gunpoint. Eventually, Mr. Keller just turns and walks away, walks towards what turns out is his vehicle, which is parked in the parking lot. At that point, Officer Powell said, "Okay, fine," holsters his weapon, approaches Mr. Keller, tries to get him on the ground, at which point the fight is on. Mr. Keller, the plaintiff, was not actually handcuffed or subdued until multiple other officers arrived on the scene. Everybody sort of piled on. Eventually they got him handcuffed, put in the car. He was, I will say that our briefing indicated he was arrested for obstruction. He was eventually charged with obstruction. He was actually arrested for assault 3 because of his actions towards Officer Powell. Officer Powell did go to the hospital, had some injuries, had some problems with his elbow, had scratches and gouges on his neck and on his face. So the question here, beginning with the Terry issues, plaintiff says in his response brief that his 1983 claim is based on the allegation that Officer Powell exceeded his Terry authority by training his gun on him. So two sort of initial questions with respect to the Terry stop. One, was there authority to stop the plaintiff in the first place, to perform a Terry stop on him? If there was, the next question is, did Officer Powell exceed the scope of his Terry authority when he pointed a gun at him? It's unclear whether the plaintiff is alleging that...
What do you think the facts are that would justify a Terry stop?
Well, we'd start with the vehicle itself. I think the case law is fairly clear that if you have a felony suspect vehicle...
You say felony suspect. Was it clear that this Chucky Mitchell had a prior felony?
He was wanted on a felony warrant.
All right, well, that's different. You referred to him as a felon. So he was wanted on a felony warrant, is that correct?
He was wanted on a felony warrant.
All right.
Yes. I'm unclear at this point. I'm not aware whether he was known to be armed and dangerous. I do know that he was known to several of the officers in the area. Aside from that, there's nothing else to indicate. The bulletin from Seattle Police Department said, "We want Chucky Mitchell on a felony warrant. Be careful. He's armed and dangerous. He's threatened to, quote, shoot up a house," end quote. That was the bulletin. And then they gave his car, etc. So if an officer is looking for a felony suspect, bank robber, murderer, felony domestic violence, etc., sees the car that's registered to the suspect, there isn't any disagreement, I don't think, in this case from the plaintiff that you're allowed to do a stop on the vehicle that's registered to the person you're looking for. Otherwise, we have to say that if you get an alert that this vehicle was seen leaving the scene of a bank robbery, and here's a suspect description, the officer has to somehow pull up beside the car and make sure that it's the right suspect in the car.
Well, but this particular plaintiff looks nothing like, apparently, the Chucky Mitchell that the police were looking for. Is that true?
I'm not not qualified to say whether or not they look alike.
Well, didn't the officers who came on the scene say that's not Chucky, and he doesn't even look anything like him? I mean, that's on the video, is it not?
They came on and said that's not Chucky.
Well, they said he's a lot taller, he's a lot heavier. I mean, physically he didn't look like Chucky, did he?
I don't believe so, no.
All right, well, that's the officers who came on the scene. They didn't believe so. They clearly identified the plaintiff as not being the person that was being looked for. Is that right?
That's right.
All right.
The officer who said that on the video, Officer Pryor, he's the one who had been involved with both Chucky Mitchell and the plaintiff in the same car just the month before in another traffic stop. So Officer Pryor, who said that, said, hey, that's not Chucky. I know Chucky. That's not him.
Let's assume that there were 10 people standing in this parking lot of the apartment building. Would the officer have an ability to make a Terry stop on all 10, based on the facts we have?
Doubtful.
Well, how about 5?
It's a case by case. 5 is closer than 10, sure.
Well, 5 is half of 10. We know that much.
Sure.
But here's a gentleman standing in a parking lot, and he happens to be near a car that's got a driver, apparently. What's the basis for drawing a gun and stopping him under those circumstances?
Well, not only the fact that who they were looking for, the Graham factors, for example, are the type of crime that was allegedly committed. You also have to take into account all the circumstances. This officer came on the scene. It wasn't a hot pursuit, obviously, but he came on the scene just a few minutes after Officer Betts had said, Chucky is in this car. This car just passed me. Officer Powell arrived on the scene before the car had even been able to park.
Well,
So
now you're kind of creating facts. As I understand it, Chucky was never in that car. He was in the plaintiff's car, wasn't he?
no, that's not the case.
Well, my understanding is that the plaintiff and this Chucky Mitchell arrived in the plaintiff's car, and that this Lisa lady, I don't forgot her last name, was a sole occupant in the car registered to Chucky Mitchell. Now, do I have the facts wrong?
At the time Powell arrived, Lisa Hill was the sole occupant of the vehicle. At the time Powell arrived.
All right, and my question to you is, do we know in which car this Chucky Mitchell had arrived moments before?
We don't know that for sure.
All right, so when you say that they saw this car registered to Chucky drive by and Chucky was in it, you don't know. As a matter of fact, I think the facts are that this plaintiff had driven a different car and that Mitchell was in that car with this plaintiff. So let's get the facts straight.
My understanding from two things. One, my understanding from the report of Officer Powell is that Officer Betts, who made the call, said, quote, had just observed a subject in a known vehicle that Seattle PD had probable cause to arrest on a felony DV case. Officer Betts stated that the vehicle, a blue 1997 Ford Crown Victoria, was occupied by a Chucky Mitchell who had threatened to go, quote, shoot up a house. So that's the information that Officer Powell had at the time he arrived, which is the relevant inquiry. Whether or not it was actually the plaintiff who he thought was Chucky Mitchell or vice versa, the fact is that Officer Powell, in his mind, had heard Chucky Mitchell is in this car and he's driving right now. So it's a little different situation if Powell had just arrived on the scene and seen someone standing in the parking lot. The information he was going on was our suspect is in this vehicle and it's moving right now. He pulls up to...
But when the officer arrives, is it not true that it was clear that there was only one person in that vehicle?
It wasn't clear at the time he arrives. It's dark out. The taillights are on. Later on, it became clear there was only one person. After the lights came on, he put his spotlight on, and he ordered both of them to stop. In the video, you can see that he's talking back and forth to the driver and to Mr. Keller, to the driver, Mr. Keller, trying to control this scene where people had split up and gone different directions. So at 10:30 at night, when it's dark, he's alone, and he just happens upon this vehicle. No, it's not clear to Officer Powell at all that, oh, there's only one person in the car, it's a woman, it's not Chucky Mitchell, the guy standing outside is not Chucky Mitchell. Terry and his progeny says that the officers have a flexible set of responses based on the information they have at the time as the case is developing. With respect to whether or not Chucky Mitchell looks like the plaintiff, again, it's irrelevant because there wasn't a suspect description that was given out. This would be a slightly different case if Officer Betts or anyone else had said, Chucky Mitchell has short hair, he's wearing a black shirt, he's only 5 foot.
Was that available to the police? Is this Chucky Mitchell? Did he have a driver's license? He must have had a license.
Sure,
a registered car.
It would have been available eventually, but this happened within a couple minutes. Betts is standing on the street holding the flag, sees the car go by and says, hey, Chucky Mitchell's car just went by and he's in it. Within a couple minutes, Powell comes across the car. So this isn't a case where everyone sits around, they've got a picture.
Did they not go to some site to find out where the address that the car was registered at?
No, Officer Pryor is the one who said this over the radio, this is the apartment building that Chucky Mitchell lives at. And he got that information just because he was familiar with Chucky.
I see.
Because he was the one who was involved in the traffic stop from just a few weeks before and had been involved with him before, which is sort of a side issue that the plaintiff has brought up is the prior traffic stop. So Officer Pryor knew both the plaintiff and Chucky Mitchell, had stopped them both in this car before. They were known associates. They were seen together. Officer Pryor had been to the residence, knew where Chucky lived. So he hears, hey, Chucky Mitchell is driving in this general direction. He gets on the radio and says, hey, check out such and such apartment complex. That's where this guy lives. Powell, just a couple blocks away from there, says, oh, I'll pull in there. He pulls in and immediately sees the car. As he sees the car, he still doesn't do anything at that point. In the video, you see that he stops, looks at the car, waits. As soon as he's spotted, they start to split up. At that point, it's 10:30 at night. He's one officer. No other officers have arrived yet. He's got a car registered to a felony suspect who's claimed to be armed and dangerous, who's threatened to shoot people. Again, he's got no backup. He sees the vehicle. He sees the vehicle running. He sees a person next to the vehicle in the residence of where the suspect lives. And immediately the scene starts to change as the vehicle and the plaintiff move directions. At that point, our argument obviously is that there's Terry authority to stop the car. The Terry authority to stop the car because of the situation would extend to a single person standing. He wasn't standing in the parking lot. He's standing leaning over the car with items on top of the car. Looks clearly like he just got out of the car or was going to get in the car. It's not a matter of, again, suspect vehicle is parked somewhere. We see a man across the parking lot. Seems to be unrelated. The plaintiff was clearly associated.
One of the issues is dealing with excessive force. Was it excessive force for the officer to draw his weapon under those circumstances at the time he ordered the plaintiff to get on the ground?
Well, it might be just a difference of terms, but I think the inquiry is, did it exceed the scope of what he was allowed to do under Terry? Did that threat of force? There are a line of cases addressing what sort of force and threat of force are you allowed to use under Terry that will not transfer a Terry stop or transform a Terry stop into an arrest. It's a different question.
Isn't that usually a factual inquiry as to when the investigatory Terry stop becomes an arrest under the law?
Usually it is, sure. The cases in the Ninth Circuit have said that, while the test for reasonableness is often a question for the jury, the issue may be decided as a matter of law if, quote, in resolving all factual disputes in favor of the plaintiff, the officer's force was objectively reasonable under the circumstances. In this case, it's unclear what actual factual disputes there may be. It's on video. We know what information went out from Officer Betts. It happened fairly quickly. There aren't a lot of factual disputes. And so the question is, based on the facts, assuming that we resolve the facts in favor of the plaintiff, which, again, I'm not sure that there are disputes. There's not much to resolve as far as what the facts are. The question is, how do we apply the law to the facts? Based on the situation, did he have a reasonable basis to believe that he could be in danger and he needed to draw his weapon and order the plaintiff to the ground? That's the crux of this. Again, based on the situation, the cases have described not exactly similar, but other instances in which use of force, threat of force, drawn guns, ordering people to the ground, all of those are well within an officer's rights under Terry, assuming that he has a reasonable basis to fear for his safety or the safety of those around him.
Well, let's just ask a couple of hypotheticals. Let's just assume that there would be a factual issue on whether it was a proper Terry stop. Would the officer have an ability to, as I understand it, as the plaintiff starts to walk away, the officer essentially puts his gun away and reaches for, grabs, holds, tackles, whatever.
Sure.
There's a scuffle that results. Would the officer have the ability to do that?
Well, if the officer was within his Terry rights prior to that, then plaintiff's actions in refusing to do anything that he had said clearly gives him PC for obstruction, at which point he can actually arrest the plaintiff. The false arrest and the use of force...
Everything's connected to that.
Yeah, everything
Terry stop.
Everything follows from the Terry stop. We would admit that if the Terry stop was exceeded, his scope of his authority under Terry was exceeded, then he's got no probable cause for obstruction, because you can't get obstruction if you're not following directions that the officer doesn't have the right to give. So it all flows from the Terry. This case is different in that respect. Most cases, those are not as closely related because the factual dispute is different. The plaintiff will say, I was complying with commands, and I did everything he said, and he jumped on me anyway. That's not the case here. The plaintiff admits that he didn't comply with any of Officer Powell's commands. So if Powell was within his Terry rights, he's clearly got PC for obstruction and for the arrest. So the false arrest rises and falls with the Terry issue.
All right, thank you. I think I understand your position. We've got about 5 minutes left. We'll save it for rebuttal.
Thank you.
Mr. Phillips, I'm having trouble with this case. I mean, I watched that, listened to the tape. Why doesn't the officer have at least grounds to start asking your client some questions?
He did, Your Honor.
Well, your client didn't do anything but basically swear at him and start to walk away. Isn't that true?
And that is indeed troubling, Your Honor. My client's conduct after the violation had occurred is troubling.
When did the violation occur?
The violation occurred when the officer got out of his car and pointed it at my client, who was an innocent person standing next to a car.
Well, there's a myriad of cases that would allow in a Terry stop for an officer to, at night, under uncertain circumstances, draw a gun. Do you agree with that?
I agree that is possible, Your Honor, but you have to look at the circumstances of the particular case, I think, to make that decision of whether it was correct or not.
So you're saying that the police did not, the officer involved did not have a basis for a Terry stop. Is that your position?
No, Your Honor.
So
my position, Your Honor, is that the officer violated my client's Fourth Amendment rights against unreasonable search and seizure when he got out of the car and pointed a gun at his head for no reason. That's our
well, I mean,
position, Your Honor.
but if he had a basis for a Terry stop. So let me, I want to be clear. I want to understand your position. Do you agree with the defense that the officer had a reasonable basis for a Terry stop?
I would answer that, Your Honor, by this. Sorry to say the government. The defendant has relied on one case that's very similar to this, the Hensley case. The Hensley case is when another agency sent out a bulletin to another agency and asked that they stop this person and identify the person. The court found that that was okay. And the court found that that was okay because in the bulletin, the wanted bulletin, it gave a description of the suspect. In this case, counsel mentioned, it agrees that there was no description of the person given. In fact, what's funny is that in this case is that the material issues of fact have been developed in a large part by the defendant's own expert, Sergeant Ovens, who testified in his deposition to the issues that like stopping the person, pulling the gun on the car, pulling the gun on my client at that time, asking my client to show his hands when he had chicken in his hands right in front of him.
All right, but let me ask, Mr. Phillips,
Yes,
let
sir.
me ask the question again, because I need to understand your position. Based on what the officer did know or believe, did he have a basis to make a Terry stop, an investigatory stop? I think it calls for a yes or a no.
No, Your Honor.
And why not?
He did not because he didn't have a description of the suspect as Sergeant Ovens testified that what he should have done when he was sitting in his car, used this computer system to find out, get the description of the person that he intended to
Right,
stop and even identify.
We know he didn't do that, but we also know that he had certain other facts at his disposal. So my question is, when you line up all of those facts, the fact that this Chucky Mitchell was wanted on a felony warrant, that he was believed to be dangerous, that he had a registered car, the registered car was registered to apparently an apartment or a location where the car was parked in the parking lot or standing in the parking lot, and that there is a male suspect that's standing right next to the car apparently when the officer pulls in. Isn't that enough to allow the officer to at least make a stop, make an investigation to find out who this person is?
The government, the defendant had a right, the officer, Your Honor, had a right to stop the car. He did not stop the car. He had a right to engage the person driving the car. He did not engage the person who was driving the car. He saw the brake lights on the car, so he knew that someone was in the car. If he believed the information that Chucky was in the car, and he saw the brake lights on the car, and he says that in his deposition, if he knew those things, then he had a right for the Terry stop to go to the car and the driver and say, "Are you Chucky Mitchell?" That's where his right, that's where it was. He had no right to engage my client. And counsel here, I'm sorry, but a lot of the facts that have been related here are not absolutely positively online. For instance, my client did not run across the street. The video speaks for itself. The court has seen the video. The video speaks for itself. Officer Powell, at page 20, line 15 to 17, was asked, "Okay, did you see him throw anything, reach into his mouth and throw something down?" Answer, "I did not." Right from the very beginning, the officer did not see what the defendant counsel is saying that he did see. Betts, as far as Betts is concerned, we have no idea what was the time frame, and counsel says, well, it was immediately thereafter. Betts said he saw Chucky Mitchell in his car. My client had Kentucky Fried Chicken in his hand. At some point, if Beth saw Chucky in the car, at some point they went to Kentucky Fried Chicken, came back, and Chucky was in my client's car, not in his car. So there was a time frame in there. It wasn't immediately thereafter. So the officer not only didn't have a description of the person he was supposed to be trying to contact, but he also had no idea if Chucky was in the car because of the time frame that was involved. And the circumstances indicate that there was a greater time than immediate thereafter that the car, Chucky's car, drove into the driveway.
Well, what is your
I'm sorry.
from the discovery you've done, what is your best understanding of from the time the car is spotted to the time officer pulls into the parking lot?
They go to Kentucky Fried Chicken, Your Honor. My client is in fact eating the chicken. They had just gotten back. My client is eating the chicken at the time, and he still has his drink. And it's his drink that is sitting on top of Chucky Mitchell's car when the officer pulls up. Counsel here says that my client looked up and saw Powell and then started reacting. He did not do that. You can look at the video yourself and you see that there was no reaction to Powell at all. The only reaction to Powell is when he was striding with his long legs across, and then Powell shone his light on him and then pointed his handgun with a flashlight on it on him. That is what happened. So there was a time frame between the time that the officer Betts said he saw the car, and finally when he was engaged by Officer Powell. In addition, Your Honor, Officer Pryor, in the prior incident with my client, they were not in the same car as Chucky Mitchell's car. They were not in Chucky Mitchell's car. They were in my client's car. So there again is a fact that's been skewed to help the defense, but in fact that is not what happened. Officer Pryor was looking for Chucky. He stopped my client. Officer Pryor engaged my client. My client did not raise the window down. Then another officer showed up. The other officer asked my client for his ID. He gives him his ID, and they let him go. That is what my client was saying, Mr. Keller was saying, when he says, get me some more officers here, because he was looking for officers to show up to defuse the situation, because obviously there was a rookie person pointing his gun at him. And I think there were reasons for him doing that.
Well, let me ask you this.
Yes, sir.
You've got a claim for excessive force. If a officer has a basis to make a Terry stop, I want you to assume that. I know that you dispute it.
Okay.
And it's dark, and the officer believes that the suspect is dangerous and that there's a felony warrant out. Does the officer have a right to brandish a gun in connection, he's all alone, to pull a gun out? Is that excessive force? Or can we say as a matter of law that if the Terry stop was proper, the use of the gun was proper?
Well, Your Honor, according to the Auburn Police-owned manual, there has to be immediate or imminent threat of death or serious bodily injury to the officer or someone else. In this case, the officer's own actions belied that he was concerned for his safety. Here again, their own expert, Ovens, said, well, if he was concerned for his safety, he should have used the door as the car for cover. He did not. He didn't do that because he wasn't afraid of this person, because he was just a thin man that he thought that he could overpower anyway. So, no, Your Honor, their own manual says that you pull your gun, and counsel says it's just a minor thing being pulled, having a gun pulled at you on him. But in fact, the gun was pulled can only be done when there's the imminent or immediate threat of death. In this instance, there was no indication that my client had a gun. He didn't have a holster. He didn't have a bulge. There were no guns on his person. When he was arrested, he did not have a baseball bat. He didn't have any kind of weapon that the officer had to be fearful of, and the officer wasn't fearful. He just pulled his gun and said, show me your hands, because that's what he was trained to do, and he was under pressure from his supervisor to up his police stops and self-contacts because he wasn't being proactive, productive enough. But his supervisor told him that in March, and in August, he is now thinking that he can now get a better evaluation and stop this guy on his own and do
Well,
it.
it isn't whether he was or was not told in March that he had to up his stops. This is a little different, is it not? This is unique. He's been told there was a car at a particular location that might have a felony suspect. I mean, this is kind of a unique situation, is it not?
Well, Your Honor, a juror could say, well, why didn't he go after the car?
Right,
If
well,
that was the information he had, then why didn't he go after the person in the car? If that was the information.
Let me ask you this. At some point, the officer grabs your client and they have a skirmish, if you will. Is your client under the law, let's assume that there was no Terry stop, but can your client under the law still resist an officer's attempt, lawfully or unlawfully, to restrain him?
Yes, Your Honor. If there is no loss of freedom at stake. In this situation, there was no loss of freedom at stake because he hadn't committed any crime.
Well, but isn't that something that the courts wish that we sort out later and not on the streets? I want to ask you about, if you are familiar with State versus Valentine. And this is the case where the Supreme Court was faced with the proposition of whether an instruction that had been given was proper. And here's what the court said in Valentine. And frankly, I had not read it until this morning, but here's what it says in Valentine. In sum, we hold. This is the Washington Supreme Court. And I'm going to paraphrase a little bit. Although a person who is being unlawfully arrested, that's your client, I gather, has a right to use reasonable and proportionate force to resist an attempt to inflict injury, that person may not use force against the arresting officer if he or she is faced only with a loss of freedom. I mean, isn't that where we are here? Isn't your client's only what he's being faced with is a loss of his freedom? He's being the officer's trying to get him to the ground and arrest him. At that point, is he not?
Not at all, Your Honor. And I have that same exact quote right here highlighted on my iPad, and because I think that language goes to the plaintiff's favor, because he wasn't facing a loss of freedom. What he was protecting himself from further injury by the officer. The officer, he turned, and the officer jumped on his back. He was protecting himself from further injury. That is what he was. He wasn't facing a loss of freedom. In fact, he wasn't arrested for felony harassment, which is what they were looking for. He was arrested for, I guess, assault of a police officer, but that was like after the fact. So he did not have that loss of freedom was in his mind at that time.
Let me just fast forward on that issue. He was arrested for assault 3, but ultimately it was revised to obstructing an officer. Is that right?
That's correct, Your Honor.
And he pled guilty to that charge. He did?
He did.
All right. You've got a false arrest claim. You've got a malicious prosecution claim. Isn't a requirement for each of those that, I mean, he pled guilty. Don't I have to dismiss those claims, false arrest and malicious prosecution?
Your Honor, again, that was my note as well, is that I think that that is probably the weakest part of his claim.
Well, I mean, do you have any case that tells me that I don't have to dismiss it? If he's pled guilty, I mean, I understand that he got deferred or he got it dismissed ultimately, but at some point, whether it was an Allen plea or whatever, he pled guilty to obstructing the officer. So, again, don't I have to dismiss those two claims?
Your Honor, I don't know if the Heck doctrine applies to those particular claims, and that's the doctrine that we're talking about, the Heck doctrine. If there's a judgment, then you can't later on bring a 1983 action. I don't know if that's really on point as far as those particular charges or claims but I know it's not applicable in the excessive force because there is no judgment in order. If he prevails, there's no judgment that will be put into question because there is no judgment right at this point in time.
You got a negligence claim. Don't I have to dismiss the negligence claim? There's no. You've got the public duty doctrine in Washington. I know you're familiar with it.
Yes.
I don't see any exception here that would allow you to sue in negligence. I mean, you can sue for excessive force and wrongful arrest, but a pure negligence claim needs to be dismissed, does it not?
I think the public duty doctrine, Your Honor, would give us some.
I didn't hear you.
The public duty doctrine would give us some problems with that, Your Honor.
And I want to talk to you about the suit against the city because I'm having trouble with that portion of your claim as well. The Monell liability requires, well, in this case, really, you're relying on some policy or practice or custom, and you indicate that he had some objective to make an average of 3 traffic stops and 1 self-initiated contact per shift, and somehow that productivity goal somehow was a policy, and that this was all part of it. But this is quite different than making a traffic stop, isn't it?
I believe so, Your Honor, but it's not quite different than making a self-initiated contact, which is what he did.
Well, he wasn't making a self-initiated contact. He was told to go to a particular location and see if they could find the car or Mr. Chucky Mitchell. Wasn't that true?
I believe so, Your Honor, but I believe the officer testified in his deposition, and I may be wrong, that he thought, and he believed that this conduct would assist him in his performance evaluations with his supervisor.
Just say that again. Let me look at the...
I believe he said in his deposition, Your Honor, and regarding this, that he hoped and believed that this incident would help him or assist him with his meeting his objectives of his performance evaluation.
Well, that may be his hope, but does that create Monell liability against the city?
Well, Your Honor, and I know that there has to be more than one incident involved, okay? In this instance, you have to consider all the totality of the circumstances when the city is involved, okay? In March 2009, he's told by a supervisor that, Officer Powell that is told by a supervisor that he has to be more proactive and more productive. In 2009, he received 4 citizens' complaints, 1 from a 14-year-old boy, 2 from women, and the other from my client, and he's received none since that evaluation period is over. The only time that he received citizens' complaints, other than when he rammed into the back of a car because he wasn't paying attention, the only cases that were citizens' complaints were derived at the time that he was under the pressure to be more proactive under this evaluation. I think the city is liable for that, and his supervisor is liable for that because of their policy. There's a question about the custom as well, and that I think it's specious conduct of the police officer who says, when the officer says, that's not Chucky, the other officer says, well, that's okay, because we got him for arrest 3 now anyway. So I think that this permeates the Auburn Police Department, and the policy time, I guess the most important thing, Your Honor, is that the time that my client was arrested, in 2009, this person had 4 citizens' complaints for overreacting and being too aggressive on citizens. Afterwards, he has none. Before that, he has none. I think that's pretty clear indicia that there was some policy decisions or policies that were driving his conduct, which resulted in my client being accosted in the way he was.
All right, I think I understand your position.
Thank you, Your Honor.
Thank you.
A couple of quick points. As far as the time, The police report says that the call from Officer Betts came across at 22:32. The arrest was made at 22:46. As you see on the video, there's at least 7 or 8 minutes of interaction between Officer Powell and Keller. So the idea that, or the insinuation that somehow the report from Officer Betts was a long time before, that's just not the case. The call came from Officer Betts. Powell went to the apartment, saw the car.
They have to get their chicken pretty fast.
Right, right. The other issue, briefly, the negligence. The court's correct. Police actions are generally not reachable in negligence. This is going to rise and fall with the federal claims, not the negligence. As far as Monell, as Your Honor observed earlier, this was neither a traffic stop nor a self-initiated contact. Not to go too far outside the record, but a self-initiated contact is just an officer on patrol investigating things, trying to be proactive. Here he received a call, officers were going to the scene. It's not a self-initiated contact. As far as reference to complaints against Officer Powell, as we stated in our briefing, none of those complaints were ever sustained. They're not a basis to find any sort of policy for excessive force or false arrest, certainly, against the city. Again, we would say that the standard for the Terry stop is fairly well established here. You've got a suspect wanted on violent crime, seen in the car just a couple minutes before. The officer sees the car in the parking lot with a man standing beside it. I would give the example, even if the suspect hadn't been seen just moments before in the car. Suppose an officer comes into a parking lot, sees a vehicle that's registered to a violent felony suspect, and there's a man underneath the hood working on the car. Under plaintiff's theory, he'd have to stop, wait for a description, go up, compare the description to the suspect, and hope that nothing changed in the meantime.
Well, so let me ask you the hypothetical I asked you before. What if there were 5 men standing in the parking lot? Could you make a Terry stop on all of them? Tell them all to get on the ground?
I think it's unlikely.
So you'd have trouble with that one?
I think I would have much more.
All right. So it's about 3 males talking in the parking lot near the car.
I think 3 males, you would have Terry authority, because the 3 males clearly could have been the 3 males that were in the vehicle that had been seen just moments before. You know, this is not a race to get out of the vehicle. If the officer sees them in the vehicle, he can stop them. But if he happens to arrive in the parking lot 30 seconds later when they've gotten out and are standing there talking, well, then Terry's out the window and the officer has to go on his merry way. That's not what the law says. I would be a little more comfortable with 3, again, because the rules about Terry stops in a vehicle are well established. Maryland Wilson, Pennsylvania Mims, if you stop the vehicle, you've got right to control the movements of everyone in the vehicle. So if Mr. Keller, for example, was in the vehicle, he couldn't have gotten out and walked away, because we've got Terry authority to stop the vehicle.
He wasn't in the vehicle. He was standing in the parking lot,
right,
talking to the person.
Right. So the question is, initially at least, does the right to stop the vehicle, which is established, does the right to stop the vehicle extend to someone clearly associated with the vehicle standing beside it? We would argue that it does, based on the timing here. However, even if we reject that, the next question is, did the officer have Terry authority once Keller started to walk away, based on the change in circumstances? We would argue he had Terry authority then too. And that's important, because he wasn't actually stopped until the vehicle went one direction and he went the other direction. So there's 2.
But, I mean, he was told to get on the ground immediately, wasn't he?
No, he was told to get on the ground after he had come around the back of the car, started to walk away, and then the vehicle pulled into the parking spot. That's when he told him.
What was the officer's original command to the plaintiff?
You get on the ground.
Well, you get on the ground and he's pointing a gun at him. Isn't that true?
Yes. I'm sorry, I'm not understanding that.
Well, so the first thing out of the officer's mouth to this plaintiff immediately is get on the ground.
Yes.
And he's pointing a gun at him.
Yes. as the plaintiff is walking across the parking lot away from him. He didn't, if you watch the video, it's important to distinguish because he didn't do that as soon as he arrived. Officer Powell's vehicle pulls up and he stops, and he's watching the vehicle. Once the vehicle goes one way and plaintiff goes the other way, then you hear the car go into gear. He pulls around the corner facing the vehicle, puts it in park, turns his lights on, turns his spotlight on, gets out of the car, and draws his weapon. And he only does that. He only approaches with lights and draws his weapon once the vehicle and Mr. Keller have separated into opposite directions in the parking lot. It wasn't an immediate thing. The command wasn't given as soon as he arrived on the scene while Keller was still standing there. So even if the Terry stop for the vehicle doesn't extend by default to the plaintiff standing next to it, even if that's the case, the question is, did he have Terry authority once the vehicle goes one way and he goes another way? We argue he does. He's got an active scene. It's 10:30 at night. They're looking for a wanted violent felon.
But I'm having trouble with that. I mean, if there was no Terry, if there wasn't the grounds to make a Terry stop originally, then the plaintiff can walk away, can he not? Isn't that? That's what I've always understood. I mean, you can't walk away if the officer has grounds to make a Terry stop. They can, but if there's no grounds to make a Terry stop, then that person can walk away. Isn't that true?
Yes, in a vacuum, sure. But the actions of a suspect and the changing circumstances have to be taken into account whether Terry authority arises at some point during the interaction.
Well, but the walking away, if there, again, hypothetically, if there was not grounds to make a Terry stop, then, I mean, if I'm walking down the street and I've done nothing, and the officer comes up and says, "Stop, I want to talk to you," I can keep walking, can't I?
Yes.
And the fact that I keep walking doesn't give the officer any additional grounds to make a Terry stop, does it?
No.
All right. So now what we've got is the car that the other car, the Chucky Mitchell car, which is moved from sitting in the middle of the parking lot to a parking space. Is that right?
Correct.
So what you're saying is that would upgrade the facts if there weren't enough originally to have a Terry stop.
That plus the plaintiff looking at the officer, looking back down in the car and taking his stuff and immediately walking the opposite direction from the vehicle, putting distance between himself and the vehicle upon seeing the officer. So if you're walking down the street and the officer says stop and he's got no Terry authority, you can keep walking. If the officer is driving down the street looking for someone in the general area and you seem to be associated with what's going on, you see the officer, you look around, you say something to somebody, and then start walking away, that changes things. So the fact that even if he didn't have Terry authority at the get-go, the changing circumstances can contribute to his reasonable suspicion that something is up here. Again, he's got the car, he's in the parking lot of the suspect's residence, he's not got backup yet, it's dark, it's late at night, it's one on at least two people, one of whom is in a running vehicle, and both of whom are separating. At that point, it's completely reasonable for the officer to what's called freeze the scene. Say, okay, nobody's going anywhere until we figure this out. That's what happened here. Everything that happened afterwards, the struggle, the eventual arrest, all that was based on the plaintiff's complete failure to listen to anything the officer had said, and complete failure to comply with even one of the commands that he was given. So that's our position. Terry stop initially, the scope of the Terry stop based on again, briefly, this idea that if you don't have a suspect description, you can't do a Terry stop. That's going to completely change our felony stop rules across the country. If you find a vehicle registered to a felony suspect, you can do a felony stop on the vehicle. That's, like counsel said, exactly what happened in Hensley. In Hensley, there was a bulletin, just like here, saying, here's our guy, we're looking for him. The officer saw the suspect in a convertible and said, hey, that's the guy that they're looking for. He went up and chatted with him. He wasn't sure whether there was a warrant, though, so he sends him on his way. A few minutes later, dispatch calls back and says, yes, there is a warrant on him. Another officer down the street or blocks away hears that and says, oh, there was a warrant on him, and he was stopped in a white Cadillac. He sees a white Cadillac drive by, doesn't see who's driving it, sees the white Cadillac that the suspect had just been seen in from a few minutes prior, and immediately does a felony stop on the vehicle. The court said there's no problem with that. He's wanted for a violent crime. He's suspected to be armed and dangerous. We had reason to believe he's in this vehicle. The only difference between that case and this case is that it was actually him in the vehicle in that case. Here, turned out that it wasn't.
In this case, I think the evidence is pretty clear now that this plaintiff was never in this vehicle. Isn't
Well,
that right?
that might be true. It's completely irrelevant. The only question is, what did the officer know, and were his actions based on that knowledge reasonable?
All right.
So sure, he may have never even seen that vehicle before. Not the question.
Thank you.
Thank you.
Well, the matter comes before the court on on the defendant's motion for summary judgment, docket number 16. I'm going to grant the motion in part and deny it in part as follows. The facts are really not in dispute. On August 11th, 2009, the Auburn police officer Christopher Powell heard a broadcast indicating another officer had seen a Ford Crown Victoria license plate 544 UBS, Washington plates, belonging to one Chucky Mitchell, who was wanted by the Seattle police on a probable cause felony domestic violence charge. Mitchell apparently had allegedly threatened to shoot up a house, and he was believed to be armed. Officer Powell and the vehicle, Mitchell's vehicle, was registered to an address at 3811 H Street Northeast in Auburn. Officer Powell drove to that apartment complex, saw the Ford Crown Victoria stopped in the middle of the parking lot, observed a male standing next to the driver's door. He pulled up, got out of his car, drew his service weapon, and directed the plaintiff multiple times to get on the ground. The facts are really not in dispute on those basic facts. The question is whether or not Officer Powell had a basis for making a Terry stop, and whether I can decide that as a matter of law. From that start of a bad evening for this plaintiff, it got remarkably worse because the plaintiff walked away. The officer essentially tackles the plaintiff. They fight. The plaintiff is then charged with assault. The assault is then reduced to resisting arrest, obstructing an officer's duties. He pleads guilty to that, and because of his compliance with all the conditions, that ultimately was dismissed. But he did plead guilty to the charge, as I've indicated. Well, let me deal with what I think are the easy claims first. The negligence claim will be dismissed in light of the public duty doctrine. Washington defines 4 instances under which a government entity can owe a duty to a particular member of the public. None of those apply here. The only thing that even is argued in the briefs is that there might be some special relationship. The court finds that as a matter of law there was no special relationship. The officer Powell was performing his duties as a law enforcement officer, and at that time owed, and the city of Auburn owed plaintiff what they owed everyone else in the public, and that is an obligation to keep the peace, if you will. The negligence claim will be dismissed with prejudice. I'm also satisfied that the false arrest and prosecution needs to be dismissed because ultimately this plaintiff did resist the officer, did obstruct the officer's attempts to find out who he was. He did plead guilty to the false arrest. He can't have a false arrest claim or a malicious prosecution claim under Washington law. Under those facts, which are really not in dispute here, those claims will be dismissed with prejudice. A municipality or a city, the city of Auburn in this case, cannot be held liable under Section 1983 claim on a respondeat superior theory. Instead, a city can only be liable if there's a policy of long-standing practice or custom, there's some unconstitutional action by a final policymaker, there's a ratification by such an official with final policy-making authority, or there's a failure to train. What's alleged here is that somehow in 2009, I think in April or March or April, Officer Powell had gotten an evaluation indicating that in fact he'd conducted an average of 1.6 traffic stops and one self-initiated contact per shift, and he had some productivity goals that he was given. The goals are not consistent with what happened here on the evening in question. The type of response at issue here could be really characterized as an officer assist type of situation where the officer hears information and is assisting others in attempting to locate this, in this case, the elusive Chucky Mitchell. There's no link that can be shown between any productivity goal of making a certain number of traffic stops and what happened in this situation involving this stop, which the defendant's claim was Terry stop. Plaintiff has provided no evidence of any policy or long-standing practice which would show a constitutional violation. I'm going to grant the motion as it relates to the city of Auburn. It'll be dismissed as a defendant. So that leaves us with the question, which I've been struggling with, frankly, and that is whether or not the plaintiff has a claim for wrongful seizure and excessive force under all of these facts and circumstances. And I conclude that there's factual issues which preclude me from granting summary judgment, and that the reasonableness of what the officer did under the circumstances here are such that a jury is going to have to sort it out and determine whether or not, given what the officer knew, the officer was justified in making a Terry stop. If he was authorized in making a Terry stop, whether the force used, the use of the gun, etc., was justified under the circumstances. The court recognizes it was dark. The court recognizes that the Chucky Mitchell character was known to be dangerous and armed. On the other hand, what was not really discussed, I don't think, during the oral argument, but was in the record, was that this gentleman, the plaintiff here, was it was summer, it was warm, he had basically a t-shirt on and shorts, and there was no bulge or suggestion that he was armed in any way. As a matter of fact, I think he had fried chicken in one hand and perhaps either a drink of some sort in the other, or the drink had been placed on the top of the car. So the facts are all such that I think it's appropriate that it be passed on to a jury to decide whether, under the circumstances here, the seizure of the force was reasonable under all the circumstances. I think the plaintiff also has an assault and battery claim under state law. I'm just unclear as to whether if there wasn't a proper Terry stop, there may have been grounds for an assault before. I'm going to leave that in the case. The pointing of the gun can't be a battery because there was no contact, but they did get into a fight, and if the Terry stop was not proper, then maybe the officer is responsible for assaulting, or at least can be sued for assaulting this plaintiff. That concludes my ruling. I'm not going to enter any other formal written order. I've tried to explain the reasoning for my conclusions here today. Let me ask the lawyers a couple questions. I think we have a trial date. I think it's in October, but I didn't acquaint myself with the exact date. It's set, I think, for Tuesday, October 15th, 4 days. Is that I think that I'm not going to be here on October 15th. That's a problem, isn't it? But I'll be traveling back to the district that day. Let me see a calendar. What would the lawyers' views be if we continued the case 1 week to the 21st? I mean, is that are your calendars available? Can you tell me whether you're available on that day to try this case, should it be necessary to try it?
I believe that would be okay for us. I know I have a November 4 trial with Judge Lasnik.
Well, I've got an October 28th trial.
Oh.
So I assume this is a 3-4 day trial?
Yes.
Mr. Phillips, how do you look that week?
Your Honor, I'm fine on the 21st, a week of the 21st, Your Honor, it's week of the 28th.
The week of the 21st is what I'm looking at.
That's fine, Your Honor, I have something that I can move if we go to trial.
All right, so we'll continue the trial from October 15 to October 21. Now we have a pretrial conference on October 7th, and once again, I won't be here. So maybe what we need to do is have that pretrial conference in late September or very early October. How are your calendars on October 1 if we had a pretrial conference at late morning, 10:30?
Mr. Jolly and myself will both be in probably at least a 3-week trial starting September 16th with Judge Bryan down in Tacoma.
So, I'm sorry, when did it start?
September 16, I believe. I can check with him and.
Well, the other alternative is to just have a pretrial conference immediately before the trial. We continued the trial till the 21st. If we had a pretrial conference on Wednesday the 16th, you obviously thought you were going to be here for a trial then, so why don't we set a pretrial conference for 1:30 on that Wednesday? And we're going to keep all of the other deadlines for filing trial briefs voir dire, jury instructions for when they're presently required to be filed. Is there anything else we can accomplish today?
If I could ask a quick clarification question on the ruling?
I'm sorry, yeah.
If I could ask a quick clarification question. If the assault claim is still in, does the assault claim only apply to the pointing of the gun or to the fight? Because if you say that he pled guilty to obstruction and the officer had probable cause, then it can't be an assault to have actually arrested him. So is the assault just the pointing of the gun and the threatening to get on the ground?
Well, where I am is that he can't sue for false arrest because he pled guilty. But if the Terry stop was not proper, and if the plaintiff was entitled to walk away when the officer grabbed him and essentially took him to the ground, why wouldn't that be an assault?
Because we've said that probable cause for obstruction is established as a matter of law. He can't have assaulted him by arresting him for something that he had probable cause to arrest him for.
I think they're not necessarily connected in that way. I'm going to leave the assault claim in the case for the time being.
For both the pointing of the weapon and for the actual physical confrontation? Okay. Thank you.
Anything else?
No, Your Honor.
All right. Is this a case that requires mediation? I mean, have I got an order ordering mediation? Have you mediated?
We were waiting, Your Honor, for this hearing.
All right. Well, but I have entered an order because we changed our local rules and the cases don't always require mediation. But in this case, I think it's old enough so that we have a mediation order in place.
I believe so.
This is a good. The plaintiff. I got to tell you, Mr. Phillips. I think you've got a difficult case. I mean, I've watched the video. I've listened to your clients carrying on. Jury's not going to like that. I mean, he's got a tough case.
I understand that, Your Honor.
And I think he understands that as well. I mean, it would have been a lot better if he'd have just complied with a couple of remarks and had been over very quickly, but that's not how it all played out, unfortunately. And we've got, I don't know that the jury would get to see the videotapes at the jail. I kept it out of considering, but we'll have to sort through that. But I'm not sure that's, well, it may or may not be relevant for damages. I don't know. But it's a difficult case just because of the circumstances here. I mean, a lot of people are going to think that the officer was perfectly justified. I mean, I've struggled with it. I'm giving you the benefit of the doubt, but it's a jury is going to be, I think, sympathetic to this officer's actions under all the circumstances. You can call it a different way, but that's certainly my view.
Very well, Your Honor.
All right. We'll be in recess. Have a nice day, folks.
Thank you.